as I can say, we are of the country opinion that the legal age of the district employee are entitled to some sum amount of compensation and working out powers under 142 the Constitution. They might be grant a lump sum amount of this 10 lakh to the legal representative.
Grateful man.
The amounts have been posted to the tribunal within 6 weeks. 6 weeks, the tribunal will identify the LRs of the deceased and will disperse the amount proportionally.
Laws may keep the appeal only for the question of law. Factually, one laws may dispose it.
So,
Question of law, that's all. We are also only pressing question.
I'm deeply grateful. Deeply grateful.
now, so from the now respondent side is over. Mr. Kama, would you like to now start or be allowed 10 minutes?
After the America's news, I thought let me come at the stage.
Yes, Mr. Kama, please.
In the presence of so many eminent counsels, I'm a little apprehensive. But having said that,
I have given a note, Your Lordship, additional submission of 17th of March, Your Lordship. I am appearing in 6 matters, Your Lordship, and the opposite side is Department of Forest, Your Lordship. I am only requesting that Your Lordship may take note of my written submissions, Your Lordship, and the written submissions, actual written submissions are part of volume 2, Your Lordship.
All right, we will take it.
I may also consider Article 38 to Article 14 and Article 43A of the Constitution while deciding the issue, Your Lordship. That's all.
All right.
What was the relief you sought for regularization?
Your Lordship, yes, Your Lordship, regularization. In 2 cases, it was about pay scales, Your Lordship. There are 6 cases, Your Lordship. So there are different issues, Your Lordship. Please, Your Lordship. In 3 cases, Department of Forest is there. In 1 case, ITI College is there. And in 2 cases, Zilla Parishad.
All right, very good.
no, sir, as I see it, this is an all or nil litigation. The other side says include all. Sorry. The other side says include all. And this side says 47 of them say that our individual establishment should not be covered. So this is a peculiar litigation. As I said, it's an all or nil litigation. Now, I want to clarify my position, first of all, as to industry in the hands of government. I think there can be no doubt that industry in the hands of government makes no difference. Industry is industry. But the industry must ultimately come within the element of 2J. It must be a factory, a business, or an undertaking. Now, the other day, my lords had asked, what is undertaking? Whether undertaking would be different or not. The answer to that, my lord, is in three or four passages of the Industrial Disputes Act. First is 2K. 2KA. Can I just take your lordships to that?
Yes.
Right. I'm sorry. 2KA says, industrial establishment or undertaking means an establishment or undertaking in which any industry is carried out. So an undertaking is also a enterprise which is industrial in its nature. It's not separate. Now, if it was separate, there would be a major problem for the workers. If you turn down and see section 25F, 25F is retrenchment. It refers only to the word undertaking. Or double F, I'm sorry. If I double F, yeah, also double F, sorry. Double F is where business is transferred. So undertaking is obviously relating to industry. It refers to the fact that an undertaking of an industrial nature is transferred. But the section does not refer to the word industry per se. Similarly, my lord, 25FFF, closure. It refers to undertaking. And therefore, undertaking must mean industrial. Now, this position also came up before your lordship's court in the context of section 25O, where it referred to an undertaking of an establishment. This court said that the undertaking of an establishment must mean a separate unit of that establishment. An undertaking is it is industry. It's either the whole industry or it's a part of the industry. And it must be read, it is still terrorism. It must be read in conjunction with the words preceded and subsequent to it. If everything else around it is industry, then surely, my lords, one word cannot by itself stand out. As a matter of interest, while contemplating workmen, the constitutional bench of this court had to consider whether sales representatives would come within the ambit of workmen. They said no. We will read the entire definition of section 2S as one section. And having said so, a medical sales representative is neither manual, nor technical, nor clerical, nor supervisory. So they said we will read all these words together and we'll come to a joint decision. So therefore, in any law, a number of words in one collocation has to have the same meaning. I trust my lord that takes care of that. I pointed out that there was a judgment of this court. I just handed it across. Is it not? It's in volume 6 of your lordship's compilation. What is it? 6. What is it? Point 1. It's in volume 6. Mother said 15, 16 and 22. 15, my lords. 15 will be at page 641. 641. Volume 6. Volume 6. All my lords have this now? Sorry. Do all my lords have it now? If you lordship return to, as I said, para 15 at page 641. It says section 25O. What was that? Applies to closure. I'm reading para 15.
Yes.
Section 25O applies to the closure of an undertaking of an industrial establishment and not to the closure of an industrial establishment. Section 25L, however, defines only the expression industrial establishment and not the expression and undertaking of an industrial establishment. It also does not define the term undertaking. Section 25L does not require that an undertaking of an industrial establishment should also be an industrial establishment or that it should be located in the same premises as the industrial establishment. The term undertaking, though it occurs in several sections of the Industrial Disputes Act, as for example, Section 25 FF, FFA and FFF, is not defined anywhere in the Act. Even a new clause AA, which was inserted in Section 2 of the amended Act of 1982, defines the expression industrial establishment or undertaking and not the term undertaking simpliciter. It will appear from the opening words of clause AA, namely industrial establishment or undertaking, means an establishment or undertaking in which any industry is carried on. The term undertaking in the definition applies to an industrial undertaking. It would thus appear that the word undertaking, wherever it occurs in the Industrial Disputes Act, unless a specific by that particular provision, is to be understood in its ordinary meaning and sense. The term undertaking occurring in section 25 FFF fell for interpretation by this court in Hindustan Steel. In para 10, the court held the word undertaking as used in section 25 FFF seems to us to have been used in its ordinary sense, connoting thereby any work, enterprise, project, or business undertaking. It is not intended to cover the entire industry or business of the employer, as was suggested on behalf of the respondent. Even closure of stoppage after this activity of the employer seem in law to be covered by this subsection. In which case, para 16. It is thus clear that the word undertaking in the expression and undertaking of an industrial establishment in section 25O means an undertaking in its ordinary meaning and sense as defined in the court in Hindustan Steel. If an undertaking in its ordinary meaning and sense is a part of the industrial establishment, so that both taken together constitute one establishment, section 25O would apply to the closure of the undertaking, provided the conditions laid down in 25A were satisfied. Now, this was a case where the doctrine of functional integrality was involved. The question was whether the factory and the head office should be linked together. Was it a separate undertaking? And the court said no, because the factory could not survive without the head office. So therefore, it was considered to be one undertaking. The undertaking means industry. And it appears in the collocation of words in 2J. So therefore, it must be given that name. Right, here it is. Now, the Act, certain sections of the Act are relevant for your Lordship's consideration. First, my Lords, is section 2K. To all my Lords at 2K. Industry, as my Lords have heard by now, means on business undertaking, trade undertaking, manufacturing or calling employed, and includes any calling, service, employment, handicraft, industrial occupation or avocation. I want your Lordships to understand that this definition is in two parts. It is not just one continuous definition. In the context of an employer, it means business, trade, undertaking, manufacture or calling of employers, and includes any calling, service, employment, handicraft or industrial occupation or avocation of workmen. So there are two separate parts of the definition. This is relevant because in Banerjee's case, this court concluded that the length and strength of the definition was reinforced by the second part. The second part therefore has no part to play in the first part. Now, if you turn to the word industrial dispute, that is section 2K. You might also have 2K. 2K says industrial dispute means any dispute or difference between employer and employers, or between employers and workmen, or between workmen and workmen, which is connected with the employment or non-employment or terms of employment or with the conditions of labor. So it is a dispute between employers and employers, employers and workmen, or between workmen and workmen. So industrial dispute comes, that is how you read section 2J industry. Industry means a dispute between workmen and workmen as much as it means a dispute between workmen and the employer. So that must be clearly understood. Now we come down to the question as to whether all and every employment is an industry. My learned friends on this side would like to say that everything is included in industry, including a charitable organization. I agree with them, except for the word charity. As far as charity is concerned, pure and simple charity, government supplying milk to working people, government giving free education, that is not industry. But short of that, anything where there is a employer and employee engaged in an activity which involves an industry would be covered. So I'm with my learned friends in totality on the question of coverage. To mine, therefore, it is not the what, it is the who of the matter. The who of the matter is not relevant, it is the what of the matter. Who can be anybody, whether it's the government or otherwise. Now, the only question will arise in the case of regal functions, whether regal functions could be covered by this aspect. I would submit that you know that today, even in defense, you have the Forces Act. So even though that is a strictly regal function of the government, still people are able to go to court. So therefore, regal by itself, to my mind, may not be a complete ouster. If there is an element in the regal function which involves an employer-employee relationship, then it is possible to conclude that even that is included within the concept of Industrial Disputes Act. However, in the case of defense, since the Armed Forces Act is there, the industry will not be drawn in. But I'm just drawing an analogy. Now, if you turn back to 25KA for a moment. So, sorry, 2KA, my apologies.
Say that if free education is provided by the government, then it has to be excluded.
The concept of charity and the concept of industry are basic industry, can't be industry.
Here it's the same. private school or a government school.
It is the object of the. If the object is not to benefit the government or to benefit a department of the government, if I'm not charging fees, then it's not an industry by its very word. To my mind, there has to be there's something more than charity in an industry. Now, I have an issue with Justice Krishna's triple test also. I'll come to that. The question my lords have raised before us, and apart from one or two of our other friends, nobody has really addressed that. I'll come to that in a moment.
For education purposes, now there is Education Act of the states. They go to the tribunal.
No,
They have a separate tribunal.
no, that is all, but they won't come under ID Act. That's my submission. Because to my mind, it is antithetical to industry.
Mr. Kama, so your argument, if I correctly understood, is to enlarge the restrictive import of paragraphs 109 and 110 of Justice Iyer's judgment. There are three categories, A, B, and
I will restrict it. I will not enlarge it. When I come to it,
you will restrict it.
I will restrict it.
And that's what
I'm sorry.
say.
Yes.
That Justice Iyer says only clause C would be carved out of the definition of industry. You would include perhaps B,
Yes.
as a charitable.
But a pure charity, as I said, I'm defining a pure charity from a charity where you charge money. Where you charge money, there is, to my mind, an industrial element. But where you don't charge a pie and you do it,
If I can clarify on. Clause A says it's an institution which is run on business lines but plows back the surplus into altruistic activity. Would you define that as?
well, I would take that as out of the act. Because whether the action is done directly by the government or is done by plowing back. But if the plowing back is in the form of fees, or if the plowing back is in the form of a revenue return, then it is an industry. But if it is plowed back on its own without taking it as income, to my mind, here the test would be income. I don't know how your lordship's illustration would. How do you plow back? If you have a pure charity, the question which comes to my mind is how does one have a plowback?
I'm just using the words in paragraph 109, where Justice Iyer says that the surplus is used for altruistic purposes.
So, your lordships are talking about industry and there is a surplus. And a surplus is used for altruistic purposes.
So that will not be.
No, that
Would definitely be an industry. We are not a charitable.
to the extent it is likely to dominant theory, we'd have to apply the dominant nature theory. If the dominant nature of the work is industrial, the fact that you plow back a little bit into charity won't make it.
Then you are proposing that paragraph 185 of Justice Jaswant Singh's is a better interpretation of.
I would think, Manoj, so. I would think so, but then there's one difficulty there. There's commercial requirement. Here, I'm not insisting on a commercial requirement.
No.
I'm only saying if you are paying somebody something, it may be purely altruistic, but you are paying a workman to work for you in that altruistic activity, and by that altruistic activity, you are earning a revenue. Then the revenue which you earn is part of industry. Now, if you, to my mind, if you just pay somebody to do altruistic work, and that altruistic work is pure and simple altruistic without any commercial or other sense, then it is not industry work. That's my point. Now, let's coming down to what my relatives had argued. I'm sure, yeah, I was showing you just 2 KA at that learned friend points out. Go back. Just to show you, lordships, now that not everything is an industry. Not everything is an industry. The moment one speaks of dominant purpose, one realizes that there is something which is not an industry and something which is an industry. So,
Utility test has to be.
so therefore, my lords, clearly not everything in this country is an industry. Where I find fault with Justice Iyer's 4 principles, or 3 principles, is that he insists that there has to be a management and employer relationship which brings about industry. I don't agree. And I'll tell you, lordships, why I would recommend that your lordships also do not agree. Because in any employment, even if it is purely altruistic, there might be a employer-employee relationship. So employer-employee relationship or master and servant relationship cannot be the test. The test has to be twofold. Actually, the act is very simple. We have made it difficult. The test is simply this: is it industry in the sense of those 4 or 5 words used on top? If those 4 or 5 words are there, next question is the person employed there a workman? Now, a workman is not in manual, technical, clerical, supervisory. Now, if you look at that category, you have to consider whether he is working, well, he comes within that. Now, for example, a supervisor, over 50,000, he's not a workman. Or if you have an industry where only sales representatives are there, they're not workmen under a division, like constitution bank judgment. In that case, even if the industry on top is business, it has to be business dealing with workmen. And correspondingly, even if you are workmen, you must have an industry. The two are co-terminus. So therefore, when you look at section J, 2J, if you look at 2J, there are parts of 2J on the top itself, separating it from workmen's industries, and there is also the necessity to consider whether the persons engaged in that industry are workmen.
So to say the word any employment of workmen, where the emphasis in the second part of the definition is on the relationship between the employer and the employee.
That's right.
It's colored by the nature of the undertaking in which the employment operates.
It goes both ways. If the undertaking is not a business, then the fact that he is a workman will not make it an industrial. Correspondingly, if it is an industry in the sense of section 2I, but the persons employed by them are not workmen.
So you say the word "and" has to be read conjunctive.
No, I'm not on the word "and." I'm on the simple thing that industrial dispute as defined is a dispute between management and labor. Now, when you talk of management and labor, you obviously speak about management as defined, and you speak of labor as defined. If either of those two elements is not there, it's not an industry. It's not an industrial dispute.
Section 2J and 2S must coalesce.
That's right. That's right. Then only will it be an industry. And I'm emphasizing this because the Justice Iyer's test, and I'll come to it in a moment. I don't agree. I only on employee-employee relationships, and that is in every industry.
Mr. Kama, you are reading undertaking as a business undertaking.
Yes.
Look here, undertaking, as far as my knowledge of English goes, has different shades of meaning. One undertaking could be establishment, enterprise. The second would be what we write in our orders. Somebody gives an undertaking that you will comply. That is promise. Having regard to the previous and the subsequent words of 2J, why shouldn't undertaking be read as a venture?
Because your lordships are aware of the fact that when you read 4 or 5 words in one definition, they must have the same meaning. You can't have industry defined as manufacturing and undertaking is something totally different.
Undertaking would be said in this sense, I have undertaken this work. In that sense also it is undertaking.
I'm supported in my submission by reference to 25 FFF. Now, if that was correct, then there can be no application for transfer. There can be no application for closure. If undertaking is not industry itself, then under 25 FFF, who is being transferred? Who is doing the transfer? Who is doing the
Purpose of 25 FF and FFF, you have to follow the rules of KA to KA.
Follow it. But that's also in the undertaking. An undertaking in any industry.
Okay, industrial establishment or undertaking, do we read only industrial establishment and undertaking separately, or industrial has to be read before undertaking also?
The second line says that. The second line in
Establishment or undertaking?
an industry.
Right, individually
There has to be in an industry.
has to be, because otherwise the word industrial would not have come before establishment.
That's right. So I'm saying, look at the entire act. If you see the entire act, the undertaking